Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about the story of the scorpion and the frog. Stay tuned, I think you'll like this. So I'm sure everybody is well aware of the story of the scorpion and the frog. The scorpion is on the side of the riverbank and he needs to get across to the other side. And so he says to the frog, "Hey, give me a ride over on your back." And the frog says, "Are you crazy? You'll sting me and you'll kill me." And the scorpion says, "No, look, I couldn't do that because if I stung you, then I would drown too. So that doesn't make any sense." So the frog thinks about it for a minute and says, "Okay, hop on." So the scorpion hops on and they get about 3/4 the way across the river and the scorpion stings the frog. And the frog says, "I can't believe you did that. Now we're both going to drown. Why did you do that?" And the scorpion says, "It's in my nature." Well, the reason that story is important is because today we get to talk about Alex Murdaugh again. Good old Alex. He's always good for a laugh or sometimes a cry, depending on how you look at things. This time it's his lawyers, Dick Harpootlian and Jim Griffin, who are at issue, and they have filed a motion to basically vacate a prior issued confession of judgment. So, first of all, what's a confession of judgment? A confession of judgment occurs in that situation where the accident's on videotape. It's very clear that the person who runs into the car is not all there. Perhaps they're inebriated. Maybe they have a drug test or an alcohol test that shows the driver was very badly impaired. And if you don't settle for the policy limits at this point, then you're going to get hit with a lot more. So they sign a confession of judgment, and everybody says, "Yes, I did it," and they ask the court to approve it. And of course, if the court approves it, then it's a judgment, and the judgment is entered against the defendant in that case. Well, Gloria Satterfield worked for Alex Murdaugh as a housekeeper and died from head trauma. And the story that Alex cooked up was that she tripped over the dogs, and as a result, he was liable. And so he got his insurance company to pay the Satterfields $4.3 million, except that when he did that, he was working with essentially in league with their attorney, who was a good friend of his, and between the two of them, they stole the entire amount of money. Well, when this is discovered, when all of Murdaugh's other sins sort of come up to the forefront, one of the things that they did in order to appear to be good guys when they go in to be tried for murder, they say, "Hey, look, we admitted we did bad things. We signed this confession of judgment." So that brings up the issue of what it is they have said in their motion to essentially get this in front of the court to ask to have it vacated. So when Alex Murdaugh was arrested and all of his financial crimes came to light, one of the things that happened was that a receiver, actually two receivers, were appointed to collect all of his assets to reimburse the people that he cheated. And of course, there's not a lot of money there. One of the things that was there was his 401k plan. So in addition to all of the people that he harmed having a claim on that money, Dick Harpootlian and Jim Griffin wanted to use about $160,000 of that to fund his criminal appeal. And the judge in that case ruled against them. Now, part of the reason that the judge ruled against them was that the Satterfields attorneys came in and said, "Hey, why in the world would you let him use that money to further antagonize all of the people that he has harmed? Why would you not instead deny that motion?" And as a result, the judge did deny the motion to allow them to use the $160,000. Now, that only makes sense since these two knew that he was basically broke when they took the case, but they took the case for other reasons. They wanted to make themselves famous in South Carolina and maybe around the world by being the guy that sprung him from the slammer. And of course, that didn't work out very well for him. But that's what is behind this. Now, let's take a look at the motion, and then we'll talk a little bit about what the Satterfields attorneys have said. When I go through this, what I'm going to be doing is looking at this in very summary fashion, just sort of giving you the bare bones outline of the motion, because the response to the motion is absolute comedy gold in that it makes such a fool out of the lawyers who have filed this Rule 60B motion. So forgive me for not dwelling on that in depth, but this is going to be something you'll appreciate when I go through the response to this particular motion. For default relief from judgment under Rule 60B filed by Murdaugh's team. And we're going to go through just a little bit of it here. It talks about the drug dealing and that sort of thing, and then it says, Mr. Murdaugh confessed judgment to plaintiffs on May 31, 2022. Defendant now moves to vacate that confessed judgment because of other misconduct by plaintiff's counsel in respect to this matter, and because the confession is void under South Carolina law. As discussed in more detail below, and for further and additional reasons will be presented at the hearing on this motion, the judgment should be vacated because it fails to comport with the requirements of South Carolina law, because it was based on inaccurate facts, and because the judgment does not serve and was not obtained for any legitimate purpose. Mr. Murdaugh makes this motion to correct these errors and to set the record straight about the events underlying this action. At this point, the motion goes through a timeline starting in February of 18 with Satterfield falling down the steps. In December 7th of 2021, there's exchange between counsel, and the counsel for the Satterfield says, Jim, symbolically, it's got to be for $4,305,000. Are back at all from $5 million, but I have to have this. It's monopoly money. Also, Alex is going to have to write just a very brief apology to the family, saying that he's sorry for what happened and what he did to the boys and Gloria, and then he takes financial responsibility. So they'll make light of that in their argument. So in December of 2021, Murdaugh agrees to the proposed confession, and then in April, Nautilus, which is one of the insurance company, files a complaint. And then May 31 of 2022, the confession of judgment is filed. So Murdaugh is convicted then in March, and they move to open it up or vacate it under the basis of fraud, misrepresentation, or other misconduct of an adverse party. The judgment is void, and the motion is made within a reasonable time, but not more than 1 year after judgment. So here they had to make it before May of 2023, which they did. The definition of void only encompasses judgments where there's not due process or where the court lacked subject matter or personal jurisdiction. They don't raise those issues. Other misconduct of an adverse party is a catch-all provision designed to include discovery abuses, witness tampering, duress, undue influence, among other forms of misconduct. So their arguments are twofold. One, the confessed judgment should be set aside because it's void, and they talk about some technical defects in the judgment itself. And then they say the confessed judgment should be set aside because it arises from other misconduct by the adverse party by and through counsel, and this motion is made within 1 year of the entry of the confessed judgment. So Mr. Murdaugh and his counsel do not challenge the confessed judgment in this case because it somehow harms Mr. Murdaugh. The confession harms Mr. Murdaugh not at all. It does not require him to pay any money, and all his money is in the custody of receivers appointed by this court. If 10 insurance companies sued Mr. Murdaugh for the same $4.3 million and all prevailed, Mr. Murdaugh's life would not change in any way. The confessed judgment only harms Mr. Murdaugh's other victims. That will become important later. And then that's it. They filed this and they asked for a hearing. Now, two important legal doctrines come into play here. First, as mentioned, standing. You have to have standing in order to recover a judgment against someone. And just like that, if you are asserting that a judgment should be vacated, then that vacation must serve your interest, not the interest of some other person. The rules require that people who have real and cognizable interests advance claims like that, not people who have no real or cognizable interest in that. So why is it that Harpootlian and Griffin are doing this? I think the reason is because Satterfield's attorneys opposed them getting the $160,000 that they sought in order to do Mr. Murdaugh's appeal. Now, it is also somewhat cheeky to assert that the reason the judgment should be overturned is because our client is a liar, and he lied when he said that this happened, and he lied when he confessed judgment. And frankly, that just doesn't make a lot of sense to me. There is a doctrine in the law that says that you have to approach the court with clean hands. In other words, if you are a liar, a cheat, and a fraudster, you can't come into court and say, hey, I was a liar, a cheat, and a fraudster, but guess what? You should look real favorably upon my request because I was a liar, a cheat, and a fraudster. That doesn't make a lot of sense, does it? But that's what they're essentially doing. The other doctrine that comes into play here is something called estoppel. Now, one of the things that happened in the criminal trial that you may recall is Mr. Murdaugh on the stand said numerous times, I lied to my clients, it was the peels, and I lied to my clients, and look, I tried to make things right, that all my stuff is with the receivers, and I did this confession of judgment, and he did these things to take advantage of that confession of judgment to show that he was a, quote, good guy, or that he was trying to make restitution or make amends, when in fact, as the motion clearly sets forth, it doesn't hurt him at all for anybody to have money out of this pot. All he has to do is know that no matter what, he's never getting out of jail. So if this does not advance his chance to get out of jail, which it clearly doesn't, and now comes back and undercuts it, and if he was to prevail on appeal, he would now face the prospect of saying that he had to vacate this judgment because he lied in court documents. So if it doesn't benefit the client, who does it benefit? Well, it would appear to me that this is done simply out of spite. Now, I have no evidence to that other than what I've just told you. But it looks to me like it's essentially the lawyers for Murdaugh saying, you opposed our ability to get paid for the appeal, so we're going to oppose your ability to keep this money. And that's just not the way things ought to go. So it'll be interesting to see what the court does with this motion. I can't imagine that they would be looking too favorably upon the motion. And I also think that if they have a sense that this was filed sort of as a let's cut off my nose to spite my face kind of thing, I do believe that they will look disfavorably on this motion. So what did Bland and the other attorneys who represent Satterfield say in response to these issues? Well, let's take a look. Also, for those of you who play golf, or even some of you who don't, you may find in this memorandum that they filed in this case some absolutely hysterical metaphor and some really great legal writing. The lawyers who did this know what they are doing. This is the memorandum in opposition to the motion for relief, and it starts out this way. Defendant's motion for relief from judgment pursuant to South Carolina Civil Procedure Rule 60B asks one simple question. May I have a mulligan? Now, for those of you who don't know, mulligan is where you hit the ball and it goes off in the wrong direction, and rather than go chase your ball, you just say, hey, I'm taking a mulligan, and you do a sort of a do-over, which I think is a pretty funny way to start this particular pleading. More aptly described through their motion, Team Murdaugh, which includes Murdaugh and his counsel, have stumbled late on the judicial first tee with a small bucket of balls, and they fire shots until they finally hit the fairway. Murdaugh is not a golfer, neither are his lawyers. There are no mulligans. Like a spoiled child, the motion is overindulged and undisciplined. Murdaugh's argument seems to be, because I committed fraud on the court in the underlying cases, I'm entitled to be relieved of my confessed judgment now. By this memorandum, the plaintiffs will expose the many whiffs, slices, tops, blocks, chunks, hooks, and duffs that have so needlessly wasted this court's time and unnecessarily caused the further victimization of the Satterfield family, thus entitling plaintiffs to sanctions against both Murdaugh and his legal counsel in order to punish their conduct and deter similar abuses. Point number 1. One cannot point to their own fraud as the basis for relief under Rule 60. Whether to grant or deny a motion is within the sound discretion of the court, and its historical power comes from the power of the court to modify its degree in equity. While Murdaugh seeks equity from the court, he has not discharged equity, therefore he is foreclosed from the relief he seeks. And there is a maxim in equity that says, he who seeks equity must do equity. It says the doctrine of unclean hands prevents a plaintiff from recovering in equity if he acted unfairly in a matter that he is the subject of the litigation to the prejudice of the defendant. He who comes into equity must come with clean hands. It is far more than a mere banality. It is a self-imposed ordinance that closes the door of the court of equity to one tainted with the inequitableness or bad faith relative to the matter in which he seeks relief. Boy, doesn't that hit the mark. To put the matter bluntly, whose hands could be less clean than Alex Murdaugh's? Even according to his own motion, Murdaugh cites as the basis for seeking equitable relief that he has lied and misled his insurers and the court. And then they drop a footnote and say, that is, if Murdaugh's latest truth is, well, true. Of course, it is not to be unnoticed that in neither the amended answer in the Nautilus action nor in the motion he's made here, Murdaugh's newfound truth has been given under oath by affidavit or by verified petition. Instead, we are asked to accept the new truth of a demonstrated serial and pathological liar without a single shred of evidence other than his broken word to support his contentions. Wow, and that's just page 2. That Mr. Murdaugh lied about the dogs is undeniably obvious from the record, according to the motion. Well, to paraphrase, Murdaugh urges the court that he should be believed now when he says he lied earlier about how Gloria Satterfield was injured. Through a twisted application of Murdaugh logic, the point Murdaugh seems to make is that if he lied about the dogs, then the insurance company should never have paid him the money that he stole. As a result, he should be relieved of the confession of judgment that he gave the Satterfield boys some years later because there should never have been a Gloria Satterfield wrongful death claim and recovery in the first place, and of course, Murdaugh gets to keep the stolen money, or something to that effect. And this, Murdaugh suggests, should entitle him to seek equitable relief from the court under Rule 60. Now, he's dropped a couple of footnotes we'll get to in a second. The motion suggests it has novel issues. It does not. It raises nonsensical issues. Moreover, the motion is nothing more than a continuation of the mockery that Murdaugh has made of his prior profession and the administration of justice itself. As to this point, however, the inescapable conclusion is that Murdaugh's admitted fraud does not entitle him to equitable relief. Slice. Murdaugh has and continues to play fast and loose with the courts, which precludes him from the relief he now seeks. 2. As discussed, infra, Murdaugh committed a fraud on 3 courts by his latest alleged about-face, including Judge Hall, Judge Newman in the murder trial, and the South Carolina Supreme Court when it disbarred him. Even here, Murdaugh only serves up half a plate of his alleged truth because he never shares what became of the money he stole. And then we get to the doctrine of judicial estoppel. The doctrine of judicial estoppel evolved to protect the truth-seeking function of the courts by punishing those who seek to misrepresent facts to gain an advantage. The goal of judicial estoppel is to prevent a party from playing fast and loose. It precludes a party from adopting a position in conflict with one earlier taken in the same or related litigation. When a party has formally asserted a certain version of the facts in litigation, he cannot later change those facts when the initial version no longer suits him. The application of judicial estoppel is an equitable concept depending on the facts and circumstances of each case, and application of the doctrine is discretionary. What the motion advances in part as a basis for relief is that Mr. Murdaugh lied about his own liability for Mrs. Satterfield's death to fraudulently obtain insurance proceeds to perpetuate his severe opioid drug habit. But did he really? Yes, in an interview with an adjuster, it is true that Murdaugh explained that Gloria's fall was caused by his dogs, a fact that appears supported by both Maggie and Paul at the time. But Murdaugh never advanced this position to the court that approved the Nautilus settlement, and he actually negotiated a release that stipulated that he had no liability. So let's look at the footnote. In fact, Assistant Attorney General Creighton Waters elicited testimony from Tony Satterfield that Murdaugh had confessed judgment to the family for $4.3 million. No one from Team Murdaugh objected or took the position that the confession was a legal nullity. And of course, the reason they didn't was because it helped their case. It is denied by the parties to be released, that is, Murdaugh, that the injuries and subsequent deaths suffered by decedent were the result of any negligence or reckless conduct on any of the released parties. Importantly, the release stipulated that Murdaugh had no liability whatsoever in the death. And of course, it cites that language. It's further understood and agreed the payment of the above said amounts is not to be construed as an admission of liability. So it then goes on and talks about the real reason Nautilus settled the claim is that it made an economic decision that the risk of litigating with Murdaugh on his home turf was just too great. And it says, tragically, Paul Murdaugh is no longer with us, a matter that will be addressed under the spoliation of evidence doctrine below. One would have to question the value or risk of Alex's statement. He was not even present and did not witness the fall or any interaction between Gloria and the dogs. Furthermore, the fact that he had a financial interest in the outcome of any claim would likely preclude the admissibility of any statement made by Gloria under the dead man's rule, which is a rule of evidence. Again, Murdaugh has misled this court that the reason the claim was paid is a result of having misled the prior court in approving the Nautilus settlement. One can only imagine that when someone has manufactured so many mistruths, it becomes difficult to keep it all straight, but the reality is neither the petitions, the orders, nor the releases mentions dogs as it relates to Gloria's fall and expressly provide that Murdaugh had no liability whatsoever. This is playing fast and loose and is out of bounds. And I tend to agree with that. It was important to Murdaugh to execute the confession prior to the bond reduction hearing for two reasons. First, he wanted to be able to report to the court that he'd settled his disputes with the Satterfields, and second, he wanted to quell further opposition from Bland Richter to his request for a lower bond. During the bond reduction hearing, Murdaugh and his legal team reported to the court that they had resolved their disputes with the Satterfield family and that Murdaugh would be signing the confession. Clearly, when it served Murdaugh's purposes to advance the validity of the confession to a court, he did so. To be certain, the court accepted the representation that Murdaugh has made matters right with the Satterfields, as it went without challenge. This is precisely the type of fast and loose conduct that judicial estoppel seeks to quell. I truly wish I had time to go through the whole motion or the whole memorandum, because it really is an exercise of great legal writing, and they do a marvelous job of knocking down all of the straw men erected by Team Murdaugh, and they do it so well. I'm going to leave a link to where you can find this on the Bland Richter webpage. They have a press release, and then they also have a link to the actual pleading, and it's very, very well done. It's one of those things that if you enjoy good writing, and especially if you enjoy stuff that makes you smile, you'll have a good time reading this. But there is just a couple of more things I want to show you. The first of those is the part about spoliation of evidence. It's kind of sad and funny at the same time. And then the second thing I want to talk about is the sanctions motion, which I think is really important. So what's the real game here? If Murdaugh is right, and he is most certainly wrong, then the Satterfields would have to prove the manner of Gloria's death, a matter that has been made impossible by the fact that through an unprecedented act of spoliation of evidence, Murdaugh has murdered the only two surviving witnesses who could have testified with regard to Gloria's fall. Thus, in asking for equitable relief from this court, Murdaugh's view of equity would be to allow him to keep the stolen money, or at least not recover it from the folks he gave it to, relieve him from the confession that he executed freely and voluntarily, make the Satterfields return to the time and expense of their prior lawsuit, and in that lawsuit tell the Satterfields they now have to prove how Gloria died, and do so without the benefit of the witnesses that he has murdered. Of course, the Satterfields' attorney is absolutely accurate. Because he did murder Paul and Maggie, the only two people who were there with him at the time Satterfield fell, there's no way to establish one way or the other what happened, other than forensically through a medical examination. Of course, that's long ago gone. So that's a pretty powerful point. And now let's look at the sanctions motion. At some point, some line somewhere has to be crossed by Murdaugh where the court will send a strong message to him and his entire legal team to stop victimizing his victims and to stop weaponizing the legal system to extract punishment. Surely the legal Rubicon has been crossed by the filing of this motion, and anyone who facilitated its filing should be sanctioned. Rule 11 is a rule designed to foster attorney responsibility and deter litigation abuse. Under this rule, a party or a party's attorney may be sanctioned for filing a frivolous pleading. And they go through and they point out all the ways in which this is frivolous. Likewise, no reasonable attorney would misrepresent to a court that the reason the confession was executed in the first place was because they had bigger fish to fry and were not paying close enough attention to detail when the fish they were referencing, that is, the murder indictments, did not even exist at the time of the confession. In the discharge of our Rule 11 obligation to consult, requests were made of Team Murdaugh to withdraw the present motion in order to avoid the time and expense of this reply. These requests were unsuccessful, as shown through the attached email chain in Exhibit S. The Satterfield boys have had enough of Alex Murdaugh. We pray the court that a sanction will issue against Team Murdaugh that will finally shake his grip. Respectfully, anything short of a sanction will serve to sanction his conduct. Well, as you can see, they're pretty serious about this, and they actually gave the defendants, they actually gave Murdaugh's counsel a chance to back away from this. They basically said, hey, if you file this, we're going to ask for sanctions. And if you don't withdraw it, we're going to ask for sanctions after it was filed. And for whatever reason, the other side decided against doing the right thing. And you have this as a result. So in my opinion, I think a court properly informed here, again, assuming that everything that's in this motion is correct and everything in the memorandum is correct, I think it's pretty likely that not only will the motion be denied, but there will be sanctions and attorney's fees here for the Satterfields counsel. Well, that's my opinion. That's what I have for you. Hopefully I've given you something to think about with regard to some of these equitable maxims, as well as the idea of judicial estoppel, which I think is an important doctrine in the law. If you have any questions, leave them in the comments down below. Like, share, subscribe, all that stuff. And of course, if you have the opportunity to be kind to someone today, to go out of your way and do something nice for them, that would be wonderful. It'll really make your day. Thank you so much for watching. Have a marvelous day. I will catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.